TCC Judgment 113 宪判2 2024 Case on life sentence prisoners serving remaining sentence after revocation of parole. High notes. Article 79-1 paragraph 5 of the Criminal Code stipulated that life sentence parolees who got their parole revoked have to serve a fixed remaining sentence of 20 years, 25 years under Provision 3. The provisions violated the principle of proportionality and individual liberty, that is, personal freedom, under Article 8 of the Constitution. Article 7-1, paragraph 2, and Article 7-2, paragraph 2 of the Enforcement Law of Criminal Code, which stipulated that the calculation of remaining sentences should apply either Provision 1 or 3, depending on the time that the reason for parole revocation happened, does not pertain the principle of lex retro non-aged, non-retroactivity of the law, and the protection of legitimate expectations. Background note: in 1997, legislators amended Article 77 of the Criminal Code, raising the parole eligible minimum term for life sentences to 15 years, 20 years for recidivists, to address the rise of the recidivism rate, including new offenses among parolees. The legislators also added Article 79-1, paragraph 5 of the Criminal Code, stipulating that once the paroles of the life sentence parolees were revoked, they have to serve a fixed remaining sentence of 20 years, which should be discounted from the calculation for the next eligible parole day. The paragraph applies to parole revocation after 1997 amendment. Said provisions were further amended in 2005, implemented on July 1, 2006, raising both the length of parole eligible minimum term and the fixed remaining sentence for life prisoners for 25 years. The parolees has to serve a 25-year fixed remaining sentence without parole. In other words, the prisoner who started serving their sentence in 2006 must serve imprisonment until 2031 before starting serving a new sentence. After that, they must serve half of the new sentence before being eligible for parole. There were 36 consolidated petitions filed by 35 people and the Supreme Court Criminal Panel Number 1. The prisoners all involved criminal cases with life sentence penalties. Parole for those sentenced to life was granted but later revoked. Consequently, the petitioner must serve 20 to 25 years before eligible for counting for another parole. The petitioners argue that both amendment of Article 79-1, paragraph 5 of the Criminal Code, and the pertaining paragraph 2, Article 7-1, paragraph 2 and Article 7-2, paragraph 2 of the Enforcement Law of the Criminal Code are hard for the people to comprehend and foresee, thus violating the principle of clarity of law, the principle of clarity and the precision of legal provision. They also contend that the provisions did not distinguish the reasons for revocation and stipulated that all the revoked parolees to serve 20 or 25 years of remaining sentences, consequently violating the principle of proportionality. This case was argued on December 19, 2023. Judgment 113 宪判2 2024 was announced on March 15, 2024. Summary of the judgment holding. Provision 1 and 3 stipulated that the life sentence parolees who were revoked of their parole, hereinafter revoked life sentence parolees, must serve a fixed remaining sentence of 20 or 25 years. The provision designated the fixed remaining sentences without distinguishing whether the parole revocation was caused by a new offense or simple violation of the Rehabilitative Disposition Execution Act, that is, a parole violation. The provisions also did not differentiate between factors such as the circumstances or severity of the new offense or the effectiveness of the parolee's rehabilitation program. Within this scope, the disputed provision violated the principle of proportionality and individual liberty, that is, personal freedom under Article 8 of the Constitution. The provisions shall cease to be effective after no more than a 2-year grace period. 2. If the amendment of Provision 1 and 3 is past due, the competent authority should decide proportionately the remaining sentences of the revoked life sentence parolees as provided in this judgment. A fixed term of 20 or 25 years is not required. 3. The final court ruling of the petitioners number 5, 22 to 29 and 31 to 35 were unconstitutional and should be quashed with their matter remitted to the Supreme Court. During the aforementioned grace period, the Supreme Court shall suspend the proceedings by rulings until the amendment may be applied. If the amendment is past due, the Supreme Court should decide their cases following this judgment. On the original court case for the petition, the Supreme Court Criminal Panel number 1 shall also decide as such. 4th, the Prosecutor General may lodge an extraordinary appeal upon the petitioner's application or ex officio for the remaining petitioner's cases. During the aforementioned grace period, the Supreme Court shall suspend the proceedings by rulings until the amendment may be applied. If the amendment is past due, the Supreme Court shall decide following Part 2 of the holdings. 5. Life sentence inmates other than the petitioners serving their remaining sentence under Provision 103 may file an objection against the prosecution's order regarding carrying out the remaining sentences after the announcement of this judgment. The courts shall suspend and only resume their proceeding regarding the objection once the amendment has been implemented. If the amendment is past due, the courts shall decide per Part 2 of the holding. The same applies to ongoing objection reviews of the same type. 6. If per Part 3 to 5 of the holding, the court shortens the remaining sentence and the new adjusted sentence is shorter than the period that the inmate has already served, the inmate shall be deemed as having completed the remaining sentence from the day they have served the shortened period and begun to serve their other sentences, if any, from the next day. There should be no ensuing criminal compensation, state compensations, or reduction of sentences for other crimes. 7th, Provision 2 and 4 do not pertain to the principle of lex retro non-agent and the protection of legitimate expectation. The petitioner's complaint in this respect shall be dismissed, as the rest of complaints shall be dismissed.